The International Covenant on Civil and Political Rights. You can check both covenants. This is mentioned twice in both covenants. So Article 1. All people have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. Now, all peoples may, for their own ends, freely dispose of their natural wealth and resources without prejudice to any obligations arising out of international economic cooperation based upon the principle of mutual benefit and international law. In no case may a people be deprived of its own means of subsistence. The International Covenant on Civil and Political Rights, Article 47. Nothing in the present covenant shall be interpreted as impairing the inherent right of all peoples to enjoy and utilize fully and freely their natural wealth and resources. So the covenant controls the domestic party. The covenant tells the domestic party, Canada, Russia, America, Britain, UK, Australia, and so forth, what they can and cannot do. They say you can limit this right and you can limit that right. You cannot limit this one and you cannot limit that one. When it comes to contributions, it clearly says nothing in the present covenant shall be interpreted as impairing the inherent right of all peoples to enjoy and utilize fully and freely their natural wealth and resources. So when they tell you you must make a contribution, when they tell you you are forced to pay a taxation, what are they doing to you? They are breaching the principle of fundamental justice. The International Covenant says we cannot be forced to contribute to a society based upon the principle of mutual benefit, and nothing in the covenant allows the state party to force us to contribute. The Tax Court of Canada. Article 3. That's the enactment regulation that controls the Tax Court of Canada. It states the Tax Court of Canada is continued under the name of the Tax Court of Canada as a superior court of record. There seems to be a lot of confusion going on concerning taxation, which is better known as contributions. That motivated me to decide to make this video and release this video. Now when we look at the tax court here in Canada, now this operation of law is going to be the same on any country again that signed up to the covenants. Why? Because your country, your state party, had to provide the provision to express international law. Now, the tax court, a lot of people think that it's a statutory court. If you watched my video from yesterday, I taught you the differences about court. The fact that a court can be a statutory court, or the fact that a court can be exercising its inherent jurisdiction, its power that operates to enforce common law or fundamental rights and freedoms. Now, when you come to tax court, most people are under the impression that a tax court is a statutory court. But when you actually check the definition of what a tax court is, you find that it's recorded and written that it states that a tax court is a superior court of record. Okay, so that breaks the tradition, or breaks the thinking that a tax court is only a statutory court. So forget about that now. We learn through their own enactment that the tax court in Canada is a superior court of record, and as such it can operate in two ways. It can be a statutory court, or it can exercise its inherent jurisdiction. When the Crown calls you to go to tax court, they are calling the individual under an income tax enactment. They are trying to get you to stand before the tax court under a statutory court, saying that you owe an obligation to the Income Tax Act. That's their operation of law that they're using against individuals. However, since the superior court, or since the tax court is a superior court of record, you can stand before that court in your natural position with your fundamental rights and freedoms. The court has the ability to access the inherent jurisdiction or to use its inherent jurisdiction. Now, they don't want you walking into that court under this side, seeking the administration of justice. Now, remember we learned yesterday that a superior court of record has automatic jurisdiction. If a right exists, then it gives jurisdiction to the court. Scarola versus the Minister of National Revenue, 2002. In Article 27, where the judgment is, he was quoting another judgment. In R versus unnamed person, it says the term inherent jurisdiction is one that is commonly and not always accurately used when arguments are made with respect to the jurisdictional basis upon which a court is asked to make a particular order. The inherent jurisdiction of superior court is derived not from any statute or rule of law, but from the very nature of the court as a superior court. In Scarola versus Minister of National Revenue, 2002, Article 25, it states, again he's talking about another judgment, in Bougie versus the Queen. It says the court, meaning the superior court, as a statutory creation, does not have inherent jurisdiction. In Board versus Board, this is an older judgment. It shows us the nature of the court and the inherent jurisdiction of the court. It says that the Privy Council, in dealing with the question of the nature of the jurisdiction of a superior court, said, if the right exists, the presumption is that there is a court which can enforce it. For, if no other mode of enforcing is prescribed, that alone is sufficient to give jurisdiction to the King's Court of Justice. Nowadays, that would be the Queen's Court of Justice. In order to oust jurisdiction, it is necessary, in the absence of a special law, excluding it altogether, to plead that jurisdiction exists in some other court. So if you walk into tax court on this side of the court, seeking the inherent jurisdiction, seeking the administration of justice, then you're taking it out, you're changing the face of the court out of a statutory court. If you walk in on this side, so the Crown sends you a letter, says we're taking you to tax court, you haven't paid your taxes, you owe us a whole bunch of money, we're taking you to court. The first thing that a person or an individual does is they run in to get a lawyer, right? They get scared and they say, I got to go to tax court, oh, I got to get a lawyer. So they get a lawyer, and now the lawyer that's going to be representing you for this case is going to be coming from the point of view of statutory arguments. So you have a Crown lawyer, and you have your lawyer now who represents you, who are both going into the tax court as a statutory court, both of them. And you're standing there, and this party here is not going to seek the inherent jurisdiction of the court. They're going to stay on this side. However, if when you get called to tax court by yourself, you go and you represent yourself, you can get into that court, that superior court of record, and invoke the inherent jurisdiction of that court. Why? Because international law grants us a right. International law says all people have the right of self-determination, and we decide who we're going to contribute our wealth or resources to. We decide, and we cannot be forced to contribute to a society based upon the principle of mutual benefit. So, international law says to man, you have a right to decide if you will contribute to the growing, to the building of the society that you find yourself in. That's an international right. And our state parties, Canada, America, Russia, they had to transfer that right into their domestic law. So state party law, international law, states that we have a choice. Contributions is a choice, and no one can be forced to contribute. No one can be forced. That's what international law says. So our state parties, our countries, have the right to create a taxation system. International law says you can do it. You have the right to create that taxation system, but what the step they don't have the right to do is to force you. Is to force you to contribute to that system. Is to force you to make a contribution to the society built upon the principle of mutual benefit. Okay, so if it's an option, if it's a right, and a right can never be forced, we can't be forced to use a right produces a choice. If it's an option, then when we come into domestic law, we should see this fact. When they create their own domestic laws concerning contributions, or what you call taxations, then the mechanism for us to express our fundamental rights and freedoms should be present. Now when we come to tax court, why didn't the legislators here in Canada, why didn't they just specifically make the tax court a statutory court? End of story. And then remove the inherent jurisdiction, remove the administration of justice, say here's the tax court, it's a statutory court, we enforce the tax enactment, period. Because then they would have been in breach of international law. Because then there would be a system in operation and in play that forces individuals to make that contribution. And the individual would have no expression of law, no mechanism of law to invoke their fundamental rights and freedoms. So that's why here, when it comes to the tax court, the domestic party, Canada, had to make it a superior court of record. Why? By doing so, they open up the court for any individual to walk in there to say, whoa, whoa, you're trying to enforce enactments upon me and say I have a duty towards this enactment and I have to make a contribution, I have to pay a taxation. However, in international law, I've been given a right to decide if I will contribute or not. And when you approach the court from that capacity, through the inherent jurisdiction, they have the right to administrate justice on your behalf. And then Canada's fulfilling their obligation. Yes, they created a taxation system. Yes, I know they're forcing people, but remember, our fundamental rights and freedoms are there for us to exercise. The state party had the obligation. They're not supposed to take actions aimed at the destruction of our rights or take actions to limit or abridge our rights. They create that taxation system, and then they are limiting or abridging our rights because they're forcing us to pay a contribution. When international law is saying you don't have an obligation to pay the contribution. And then when we look at their own laws, we see that rather than just forcing the individual to walk into a statutory court where they're going to be forced to pay that contribution and they can't say anything, they leave the court open in case someone walks in there and says, hang on, I have a right that exists, and that right comes from international law, and the enactment or the actions that you guys are putting upon my life right now are breaching my fundamental right. And that's why I'm in the court. The Crown, you called me in court here now, claiming I didn't make a contribution, claiming I didn't pay a taxation. You wanted to bring me into court under statutory obligations, stick me with this burden, make me pay, but I came to understand my rights, and I know where I'm standing. And before that court now, I'm going to talk to the judge as a man or a woman, and I'm going to say I have those fundamental rights and freedoms. And international law recognizes that I have the right to contribute. And this party is trying to force me to make a contribution. And they're violating the Constitution of Canada, 1982, Article 26. And they're violating the Constitution under Article 7. Because these allows me to express my rights, my fundamental rights and freedoms, irregardless of their public law. And in fact, they're doing even worse. Why? Because if I look closely in international law, what does it say? It says that in no case may a people be forced to make a contribution to a society based upon a principle of mutual benefit. In no case may a people be forced to turn over their wealth and resources, and you guys are forcing me to do it, state party. You're forcing me to turn over my wealth and resources, so you're guilty of breaking the covenant. And you promised that you would not take any actions aimed at the destruction of these rights, but here you are doing it. But when I look into the law, I see that you preserved the ability for me to exercise the right. You preserved it in law. You didn't tell me I had the right, but nevertheless you preserved it in law. The International Covenant on Civil and Political Rights, Article 5. Nothing in the present covenant may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized herein, or at their limitation to a greater extent than is provided for in the present covenant. They cannot limit rights and freedoms if the covenant does not allow them to do it. If they limit your fundamental right and freedom, they are breaching the principles of fundamental justice. Here in Article 5, it says they cannot take any act or perform any act aimed at the destruction of these rights and freedoms, except the covenant allows them to limit it. And, as you saw, when it comes to contributions, they cannot limit it. In fact, the covenant specifically states nothing in the covenant allows them to force you to turn over your resources and wealth. It's the only right in the covenant that's protected in that way. The Tax Court of Canada, Article 19.2, Constitutional Questions. If the Constitutional validity, applicability, or operability of an Act of Parliament or its regulations is in question before the court, the act or regulation shall not be judged to be invalid, inapplicable, or inoperable unless notice has been first served on the Attorney General of Canada and the Attorney General of each province in accordance with subsection 2. The notice must be served at least 10 days before the day on which the constitutional question is to be argued, unless the court orders otherwise. So when you look into the tax court enactment, that's the enactment that controls the tax court. You find in Article 19.2, wow, I dropped my pen twice today. You find in Article 19.2 that it states that you can launch a constitutional challenge against what's going on. You see, they preserved our right. Why? Because if they didn't put that in there, if they didn't put the fact that you can launch a constitutional challenge, then they're sticking you in a statutory court and they're forcing you to pay. End of story. Now they allow you to make a constitutional challenge. Why? To seek the administration of justice, to access the inherent power of the court, to have your remedy produced for you. International law again says that we have the right to contribute, and they cannot limit that right. So when we look in the Constitution Act of Canada, Article 24, it says anyone whose rights and freedoms have been denied, they can apply to a proper court of jurisdiction to have a remedy produced. And it further states that in Article 7, everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof except through a principle of fundamental justice. And in Article 26 it says the certain rights and freedoms that are enumerated in the Constitution Act will not be taken as Canada denying that there exist other rights and freedoms that are not listed in the Constitution Act. So through Article 26 and Article 27, we can jump, and Article 7, we can jump right back into the international covenants, Article 1.2, and claim our right, and say I have a right to contribute, not an obligation. And they're trying to force me, they're trying to force a contribution on my part, which is breaching the principle of fundamental justice. Well, what do I mean? Well, when I look into international law, it does indeed talk about contributions. And it says that the state party has the right to create a taxation system and that we can voluntarily contribute. But what the state party doesn't have the right to do is to force a contribution from me. They don't have that right. That's the starting principle of this contribution, of the fundamental principle of justice concerning contribution. Now, when I look into the international covenants, it's the only right that is mentioned twice in that way. 2 times in each covenant is it brought forth that the people have the right of self-determination. In no way can their resources or wealth be forcibly removed from them. That's what it says twice. Now you have the obligation, domestic territory, to bring those operations of law into your domestic law. That's what you had to do. Now I'm here on your state party's territory and you're claiming to me that you have the right to force me to be taxed. And I'm saying, whoa, your actions are breaching the principle of fundamental justice. Why? Because international law says it's a choice. Your domestic law is telling me I must. There's a contradiction there. You guys created the contradiction. How do I defend myself? Well, the avenue is left, open and available. They make the tax court a superior court of record. They allow you to access the inherent jurisdiction to seek the administration of justice. They further provide you the option within their enactment to launch the constitutional challenge, which brings in foundational law, natural rights and freedoms, which allows you to stand there and say, I have natural rights that are being limited or abridged. And that's what you can do. Most people, when they hear about tax court, they automatically get afraid. And then secondarily, they automatically think that they're walking to a court that cannot help them, that cannot hear them. Because within it, somehow, they've got the understanding that this court is a statutory court. They don't even understand what they're saying, but they think that if they just go to this court, the only thing the court can deal with is the income tax enactment, and that's it. If they would have a better knowledge and understanding of what type of court they're walking into, they could exercise their rights and get their remedy against the one who is trying to seek a contribution. You see, here in Canada, the CRA is considered an agent of Her Majesty. If you actually look into the laws themselves, it's actually declared that this CRA is an agent of Her Majesty. Okay, not just a corporation, is considered an agent. As an agent, then it owes the same obligations that Her Majesty would owe. If Her Majesty had promised when she signed onto the new Constitution Act of Canada and when she signed onto the international covenants, she promised that she would allow contributions to be a choice. So her agent is under that same accountability. And if her agent, through the form of the CRA, comes to you and forces you to make contributions, then that would be a violation against international law. That would be a violation against the principles of fundamental justice, as I see them. Again, nowhere in international law does it talk about taxation. If you read international law, you're not going to find words as such as taxation. But they do talk about the system of taxation. And if you understand what you're looking for, it's clearly defined. Because when we are brought up in our state party territories, we're taught from a young age, we got to do our part, we got to contribute our part to the society built upon the principle of mutual benefit. They say if you don't pay your part, the whole society suffers. And that's exactly what's going on. So your right and freedom as an individual, man or woman, has been preserved for you. If you're being summoned to a tax court, the worst thing you can do for yourself is to get yourself a lawyer. The worst thing. Why? Because then you're going to automatically keep that court in a statutory jurisdiction. That lawyer who's going to represent you is going to only argue from the point of view of enactment. And the Crown is going to only argue from the point of view of enactment. You're not going to be able to change the form of the court, to get in there, to testify on record to your status as an individual man and woman, and then to begin to explain the principles of fundamental justice that the Crown has breached against you. You won't get that chance. If you're summoned to tax court and you defend yourself, then you're able to bring forth this operation of law, this mechanism of law. Canada, America, Russia, they are members, state party members to international law. We have rights and freedoms that are guaranteed in international law. They must bring these rights and freedoms into domestic law. Concerning contributions, it remains a choice, but yet they create domestic law that tries to force a contribution. This is a breach of the principles of fundamental justice as it pertains to international law. I can seek a remedy against the state party for doing that. And when I look for the remedy, they left it open in the tax court as we've seen, by making it a superior court of record. Federal Court Enactment. Article 26, number 27 is what we're looking at. Jurisdiction of the Federal Court of Appeal. An appeal lies to the Federal Court of Appeal from any of the following decisions of the Federal Court. Now we scroll down and you see it says appeals from Tax Court of Canada except from informal procedure. An appeal lies to the Federal Court of Appeal from a final judgment of the Tax Court of Canada. So you can appeal to the Federal Court if you have a decision from the Tax Court of Canada. And what are the reasons that you can appeal to the Federal Court? It tells you grounds for appeal. The only grounds for an appeal under subsection 1(2) are that the Tax Court of Canada, now watch, B, failed to observe a principle of natural justice. So if the Tax Court of Canada failed to observe a principle of natural justice, procedural fairness, or other procedure that was required by law to observe.